A courtroom battle where second chances collide with consequences. That's what we're watching unfold today. A defendant comes before the judge asking for another opportunity, arguing that family struggles, addiction, and personal hardships played a role in her actions. But the judge has heard the story before. Multiple violations, previous interventions, treatment programs, and repeated chances. The question hanging over this courtroom is simple. When does compassion turn into enabling? And when does accountability have to take priority? Stay with us as we break down the emotional arguments, the judge's tough decisions, and the moments where the courtroom tension reaches its peak.
Mr. Rojas, you may proceed with argument.
Thank you, Judge. In the updated PSI, the recommendation, the last recommendation from probation is safety continuum.
Go ahead, I'm sorry.
And certainly, Ms. Harris is willing to do that. However, she would ask the court to consider something else given her circumstances. She's, as stated in the PSI, she's heard things about the JCDI program. She would like to have a chance in the JCDI program. Certainly, she feels that the reason that she relapsed was because she had some things going on in her life. She had a couple of cousins back last year that got shot, and her dealing with that herself and seeing the way it affected her mother caused her to relapse. But the reason she's asking for JCDI rather than safety, Judge, she's got a young child, a young daughter who has some medical issues. Her mom has been taking care, Ms. Harris's mother has been taking care of the child while she's been in custody, and the mother is here, the grandmother's here this morning, and I've spoken with her, Judge. When Chastity is out and she's taking care of the child, the grandmother says that she takes care of the child and she's tremendous help to the grandmother taking care of the child, and the child is going to need some surgery coming up.
Here we see the defense making an emotional appeal, not denying the mistakes, but asking the court to consider the circumstances behind them. The argument focuses heavily on family responsibility, especially the medical needs of the defendant's child. But sentencing decisions are not based only on hardship. Judges must also weigh public safety, criminal history, rehabilitation efforts, and whether previous opportunities were successful. The big question for viewers is this: should personal circumstances change the outcome when someone has already received multiple chances? Or is the court's responsibility to focus on repeated behavior?
Safety, just so that she can get out and take care of her child. I think Chastity wants to address that with you as well, Judge.
So here's the thing though, Ms. Harris, and it's a bit frustrating to me. I feel for your family that is helping take care of your child, but it's not on me if you're not there to do that. And so using that doesn't really go very well with me, because it's you that put yourself where you are. You're a convicted felon. You've been given chances at probation that got revoked. You got time in prison. Then you are placed on probation and given this great opportunity for possessing a firearm while you're on probation. You get another case while you're on probation for the first unlawful possession. I give you another chance on probation with a possession of a controlled substance. I get the argument that you need help. I send you to Safe P. You do Safe P. You get out for ongoing support. You go through the drop program. Did well for a little bit, relapsed, and when you relapse...
This is the turning point of the hearing. The judge is not saying that addiction is not real. In fact, the court acknowledges that treatment and help are necessary. But the judge is focusing on a different issue: whether the defendant has taken advantage of the many resources already provided. According to the court, this was not a situation where help was unavailable. Multiple programs, supervision options, and rehabilitation opportunities had already been offered. The key legal question becomes whether another alternative will create rehabilitation or simply repeat the same cycle. What do you think? Should courts continue offering more chances, or does repeated failure require stronger consequences?
It's concerning to me that in the update PSI, she denies that she has a drug problem when clearly that's a big issue. And I do feel sorry for the situation that she's in.
We're going to find, Ms. Harris, that again you entered your pleas of true to counts 1 and 3 freely and voluntarily. I find those counts true. Also find count 2 true. Find sufficient evidence to find you guilty in each of your cases. And cause number 17-28222 finds you guilty of the third-degree felony offense of possession of a firearm by a felon, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 20-35466. What level offense is that one? It could get worse. You probably shouldn't talk. It could get worse. I had written down a higher number. So your attorney bought you, or your grandmother. And cause number 20-35466 finds you guilty of possession of a controlled substance, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. They will run concurrently, which means together at the same time. I'm going to hand you, I need y'all to sign this, please. These were not plea agreements. You do have some rights to appeal. You need to sign that with your attorney showing that you have a right to appeal. And then I'll get you a copy of that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas and hear it. Good luck to him. You can go back with the bailiff.
The courtroom now shifts to another defendant and another serious firearm-related case. The judge's tone changes because the issue here is not only the current charge, it's the pattern behind it. The court references prior convictions, previous warnings, and concerns that earlier opportunities did not lead to better decisions. A judge's sentence often reflects more than one incident. It considers history, risk, and whether someone has shown they can follow the law when given freedom. This raises a difficult question. When someone repeatedly ignores warnings, how much responsibility falls on the court to intervene?
Just revoked back in October of 2021 and received a state jail sentence. Whose court was that in? Was that here?
Yes, ma'am.
So I know then for certain that I read to you those written admonishments about not possessing, waived your right to appeal. I understand that you're fairly young, but you've been given some opportunities already. And obviously you're out there doing some things that could lead you to be in here for something much worse, where you've actually shot someone. It's just not, the running around with guns and shooting has got to stop. And all I can think of is the longer I can keep you away from society, probably the better at this point, because you can't learn. You haven't been able to learn from your past mistakes. I hope that you do, and I hope that you do this time and you get out and you change your life. But you're going to have to make those changes. There's help for you out there wherever you need it. There's help in TDC if you need it. But I don't feel like I have a choice today. I'm also handing you, just like I did before a couple of years ago, the written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you again. You should pay attention. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff. I feel like I've seen this. You have maybe one of the co-defendants that I did something on. This is very familiar to me.
Unfortunately, it's a pretty common fact pattern. It's four people riding around the car at 12:30 in the morning. There's 3 guns in the car.
Yeah. Okay.
And I'll just so the court's aware, the driver, Mr. Joseph Matthews, who was charged with felon possession of a firearm for the firearm that's in the glove box of the car, he was on parole after taking a plea deal for the offense of tampering with evidence for his involvement in a homicide. Mr. Dorsey, who fought with the police once they discovered a firearm in his waistband, is also a multiple-time felon. And then Mr. Sam has been convicted out of Harris County as a felon, as well as being on probation out of this court, Your Honor. So there was 3 guns in the car.
Now the court is dealing with a much broader public safety issue involving multiple individuals, multiple firearms, and multiple criminal histories. The prosecutor lays out why this situation is especially serious. Several people inside one vehicle, several alleged felons, and guns involved, while some individuals were already under supervision. The judge is not only looking at the immediate accusation, but also whether releasing someone back into the community creates additional risk. This is where bond decisions become complicated. It's a balance between an individual's rights and the court's responsibility to protect the public. Do you think denying bond was justified based on these circumstances?
Motion to revoke a deferred with several other people with at least 3 guns, other ones that are on parole and convicted felons as well. Obviously, all of that's a violation of your probation, I think, in the interest of the safety of our community. And based on all of the factors set forth in 17.15, I am going to deny that bail be set in this case. If you will get that other case fast-tracked if possible, so that it can go through the grand jury process. If something happens and that case is not indicted, then I will reconsider at that point. Mr. Rojas, I would allow you to file another motion and I would reconsider that. And then once that case goes through that process, if it is indicted, then I want to move as quickly as we can. If there's going to be a plea of not guilty in that case, and then it would probably be my desire to go forward on that motion first if we need to.
This courtroom session showed several examples of how judges weigh rehabilitation, accountability, and public safety when making difficult decisions. Ms. Harris's case focused on addiction, repeated probation opportunities, and the court's belief that previous treatment efforts had not created lasting change. Mr. Turner's case centered on firearm possession as a convicted felon and the judge's concern about escalating behavior. The final matter involved alleged firearm possession among multiple defendants and resulted in bond being denied due to probation concerns and community safety factors. The bigger takeaway is that courtroom decisions are rarely about one single moment. Judges consider history, previous opportunities, legal obligations, and the potential consequences of future actions. These cases highlight the difficult balance between giving people chances to change and protecting the public from repeated offenses. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.